All right, this is a letter from Francis Schaeffer Cox from Marion Prison on May the 1st of 2014. He wrote it to gun owners of America. Also, I think the Freedom Outpost video that I just uploaded, I think that entire article was written by Larry Pratt with Gun Owners of America. I'm pretty sure. So this letter was written by Schaeffer Cox, Gun Owners of America, May 1st, 2014, 8001 Forbes Place, Suite 102, North Springfield, Virginia 22151. Open letter requesting assistance. Dear Mr. Pratt, thank you so much for taking an interest in this case. I believe that an amicus curiae brief by GOA will go a long way towards helping defend not just my rights, but the rights of everyone who shares our constitutional and Second Amendment values. However, it is imperative that Miss Elliott be replaced if our efforts are to have any effect. Whenever the anti-gun people propose legislation that would move the legal boundaries and infringe upon the right to keep and bear arms, it causes an uproar, and they end up strengthening their opposition and getting nowhere with their gun control bills. So far, so good for us. But I believe this case represents a frightening and perhaps highly effective change in strategy by our opponents who love power and see free people as a liability to the elite's agenda. Their new strategy is two-pronged. First, it circumvents the strength of the Second Amendment lobby by going completely around the legislative process and straight to having members of the executive branch take unprecedented actions against Second Amendment rights in the hopes that no one will be able to stop them, and it will establish a new normal. Second, rather than criminalize guns, they are trying to criminalize the beliefs commonly held by gun owners. The vague and flexible conspiracy statute under which I was ostensibly charged is quite dubious to begin with, but this case takes it to a whole new level. Up until now, a conspiracy required two or more people to agree to commit a crime, and then to take overt action in furtherance of their mutual criminal objective. In my case, there was no agreement to commit a crime or overt act in furtherance thereof. Quite the opposite, actually. When the government provocateurs tried to convince me to join them in plotting a crime of violence against the government, I responded that it would be a fruitless gesture. No good would come from it. It would heap more burden upon my family and on your family, and that's not who we can be, and that I'm going to be like Gandhi, not Rambo. The provocateurs responded by telling me that they were going to kill me if I refused to join them. And this, two more people, including myself, agreed that I had best get out of Dodge. We then took overt action in furtherance of our mutual objective by packing up my wife and kids and our household goods and heading for a new country. All of this is well documented by the FBI's own secret and warrantless audio and video recordings of every detail of our family life as these events unfolded. The government doesn't dispute any of the facts. They simply argue that they are immaterial because I'm not charged with conspiracy based on any of those events. The theory of conspiracy the government relies upon, that the district court allowed to advance and that will set controlling precedents if uncontested on appeal, is based entirely on my belief in the original construction of the Second Amendment. I believe the Second Amendment wasn't put there just so we could shoot squirrels and burglars. I believe it was put there as a final check on a government that could possibly one day become dangerously insubordinate to we the people. This isn't something I thought up myself. I got it from reading the Declaration of Independence, the Constitution, the Federalist Papers, early Supreme Court opinions, the writings of John Locke, Thomas Jefferson, Patrick Henry, George Washington, John and Samuel Adams, Ben Franklin, Lafayette, and dozens of other legal and historical figures much smarter than I am. The prosecution had no difficulty proving that I believed this. It was on my State House campaign flyers. I had given speeches to that effect to stadiums full of people, given TV interviews, and even gotten state legislation passed to further protect the rights of Alaskans to keep and bear arms. The government, with the cooperation of the district court, advanced their case under the pioneering theory that my political views constituted an agreement that my collecting guns and ammo amounted to an overt act in furtherance of that belief/agreement. This isn't fear-mongering, future speculation about gun grabbers. It's here and now. It's already happened. They said to themselves, okay, if we can't confiscate your guns, we'll just confiscate you. They tried it, and so far it's worked. They effectively placed a criminal liability on any good, wholesome, hard-working American who cherishes their gun rights and has said so. The government's not going to go hog wild and start rounding up people. That would backfire, and they know it. What I see them doing is securing the necessary precedent through cases like mine, and then using it very selectively to take out key talent within the Second Amendment lobby, causing sort of a slow bleed that leaves everyone else so scared that they are effectively neutralized. These scheming knaves know exactly what they are doing to us, and they are frighteningly good at it. This brings us to an indispensable component of their efforts to get and maintain this new precedent: a defense attorney who will not challenge them in appeals court. They have this in my current counsel, Miss Suzanne Lee Elliott. Suzanne Elliott of Seattle is a left-wing gun control advocate on a mission. A few days later, after I filed a notice of intent to appeal, she asked to be appointed to the case. The court did so, and now I'm stuck with her unless I can get private counsel. My first clue that Susan Elliott was acting against my interest was when she would not give me access to my own case files. I became more suspicious when she started avoiding calls from my family, friends, supporters, and previous attorneys. The government had committed some major violations of the rules established under Brady v. U.S., which requires the prosecution to provide the accused with any favorable evidence the government knows of. When I brought this up to her, she told me that bringing that up on appeal would only reignite old controversies and do us more harm than good. Then she stopped answering my correspondence. At this point, I, through my own research, learned that these same prosecutors had committed identical Brady violations at the same time, in the same town, in the same political circles, in 4 cases that were closely related to mine, and that all 4 of those cases had been overturned on appeal as a result. I pressed Suzanne Elliott on this even harder, only to learn that she also was not going to contest the government's unprecedented application of the conspiracy statute to Second Amendment and political beliefs. I couldn't let her do this to me, my wife, and my children, or to America. So I filed a motion on my own explaining that Suzanne Elliott and I had a conflict of interest and I needed a different attorney. I was trying to give her a gracious out, so I didn't go into detail in that first motion. Unfortunately, rather than bow out, she's dug in. She filed her own motion opposing mine and showing her true colors. She's actually asking the court to change my sentence from 27 years to indefinite civil commitment. Here's a section of her motion. This is insane. What
is civil commitment?
I guess it means forever. I don't know. Indefinite. This is his own freaking lawyer. His own court-appointed lawyer. Cox's political delusions. This is his own lawyer writing. This is insane. Cox's political delusions were supported by his membership in the Alaska Second Amendment Foundation. Cox was the spokesman for that group. The foundation's goal was the enactment of state legislation that would allow Alaskans to make firearms in Alaska, subject only to Alaska law. The group even met with local FBI and ATF agents and presented their proposals. Cox came to believe that the new President Obama was going to tell law enforcement to enter citizens' homes and take their guns. There are sound public police reasons to determine Cox's precise mental status so that he can be treated while in custody and before his release into the community if his convictions are upheld. For these reasons, the court should stay the briefing schedule in this court with directions to schedule the appropriate examinations under 18 U.S.C. 4241. 4241 is indefinite civil commitment. Suzanne Elliott concludes that because I lobbied for stronger protection of gun rights, had open dialogue with federal agencies about our efforts, was the spokesman of a Second Amendment foundation with thousands of members, and had a deep distrust of the Obama administration, this means I have, in her words, political delusions, for which I need to be locked up indefinitely and forcibly treated. Let that sink in for a minute. Selah. This isn't something that might happen. It already has happened. I'm writing this letter from an 8x10 cell in a highly secretive prison unit just for political prisoners. It's already worked. They've already done it. It's the law of the land. If we don't want them to keep doing it, we have to get the appellate court to reverse what's happened. I'm reasonably certain they will, provided that we put the proper questions before them. But that won't happen if Suzanne Elliott gets her way. That's why I need an attorney who is on our side to file a notice of entry of appearance. If Gun Owners of America is going to file an amicus curiae brief, you should really just go ahead and make a GOA the attorney of record. That way we won't have Suzanne Elliott arguing against us in her brief. Of course, my life's on the line here, but this is way bigger than one guy in prison. This is an attack on our values and quite possibly the most dangerous foot in the door we've seen in a lot of years. It means that you, Charlton Heston, and anybody else who's ever talked tough about the Second Amendment can go to prison for it, and it's 25 to life. It's not some halfway house crime. Every one of your members needs to be made aware of this case because it directly affects them. We need to circle the wagons and get rid of Suzanne Elliott. Mr. Pratt, I'm asking you to please have one of GOA's attorneys step in as an attorney of record. This is a case of great significance and a wake-up call to all who cherish their rights. I need you. We all need you. For liberty. Francis August Schaeffer Cox. Man, this dude can write some powerful letters, let me tell you. I'm going to get this uploaded to YouTube, and we've got even more. It's just a wealth of information that's been produced over the past 5 years.
Civil commitment. Involuntary civil commitment is the admission of individuals against their will into a mental health unit.
Let me just say that again. Aaron, could you please read that again? She's defining what the word civil commitment means.
Involuntary civil commitment is the admission of individuals against their will into a mental health unit.
Freaking sane. This guy's got to be set free, and we got to hold Obama accountable for what he's done. This is absolutely insane.